to our continued existence as a rule of law country. What does the DPP do instead? They also brazenly even attempt to fill the gaps for the DCI or the IG by even attempting to adduce evidence from the bar. Evidence that is not even in the affidavit of the corporal who purportedly has the knowledge of first-hand information for why this accused person should be held any longer than is necessary. Where does that leave the policy or constitutional objective for why the DPP was created as an independent office to check the Inspector General of Police in the discharge of his mandate? A danger, that is a danger. To the common bond that I alluded to, that this court must guard against. And my lord, all that I have said summarize into this very simple submission. We are before you seeking reasonable bail terms for this gentleman, the accused persons. Your Honor, does the conduct of the IG, does the conduct of the DPP count for something as you consider my learned friend, Ms. Asha Bashir, has submitted to you that he who comes to equity must come with clean hands? The conduct of the DCI, the conduct of the DPP that I have outlined in very brief terms before you, does that, Your Honor, count for something? Does it hold any weight in your decision or in your consideration of the application pending before you for the detention of these accused persons for a day longer? It surely must. The misconduct that I have alluded to is not just any misconduct. They are violations of the Constitution. Article 2 is very clear in that regard. Any violation of the Constitution, they may not have any fatal effect to the charges before you, but it surely must have some effect and weight on your discretionary powers in considering an application for bail and for bond. That said, Your Honor, the law on bail and bond applications is fairly well settled, and I will not rehash that law or the principles that are applicable, save to invite you, Your Honor, to always bear in mind the policy guidelines by the NCAJ on bail and bond of 2015, and in particular, the purpose or utility of bail in a criminal prosecution such as this. That utility, again, Your Honor, is fairly straightforward, and I will not rehash it. I just want to emphasize on one point, and that is the burden of the prosecution in demonstrating compelling reasons. Compelling reasons why an accused person should not be denied bail or bond. Again, it is fairly well settled, Your Honor, that that burden reposes in the prosecution. Only shifts to the accused persons where compelling prima facie reasons are demonstrated to your satisfaction. Your Honor, compelling reasons are questions of law and fact, and therefore can only be presented to you either by evidence or by reference to specific provisions of the law to justify